In a recent video, TheQuartering said he was being forced to sue the new operators of exclusivelygames.net. Is he being serious? Is he talking nonsense? Let's talk a little bit about intellectual property. Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we are talking about TheQuartering and his allegation that he is being forced to sue the new operators of exclusivelygames.net. Now, if you don't know about this, Jeremy Hambley ran a website called exclusivelygames.com up until very recently, in which he has pulled the content off the website and put it on some sort of hiatus. Some people claim that he has shut it down. He seems to indicate that he might return to the project at some point in the future or revive the project. But at this point, the website is non-operable. So, as some members of the Exclusively Games team or community or something decided they liked the project and wanted to continue, they have created exclusivelygames.net. It is quote-unquote reborn for gamers by gamers, and we'll take a look at that in a minute. Now, here are a couple of the problems with this scenario. As I said, Jeremy has said that he is being forced to sue to protect his intellectual property rights. And while being forced to sue is a little bit hyperbolic, he does have an interest in suing for the enforcement of those intellectual property rights, particularly when it comes to trademark. When you have a trademark, you have some level of duty to protect your trademark. And if you don't do that, it can become abandoned. And that is an important thing if you're looking to keep the ownership rights that you have in trademark. But this leads to a question. What is trademark? What is copyright? What is at issue in all of this? And how does this work out? Like, what does it look like? What is Hambley actually protecting? Because intellectual property actually covers a broad category of actions, and not all of them make sense here. Specifically, copyright and trademark do. So we're going to walk through and talk about the copyright and trademark issues, and then we'll go ahead and talk about what kind of legal action that looks like, how that may play out. And I have to say, right now, nothing has been filed to my knowledge. I don't know if threatening letters have even been sent. Right now, all I'm aware of is a YouTube video that Jeremy Hambley created, and that can be found down in the description below if you wanted to check it out and see what he has to say about it, because he's the guy who's in control of all this. That being said, let's take a quick gander at the original Exclusively Games site, which I grabbed from the Wayback Machine, just a snapshot of what the webpage looks like. We'll take a look at the new exclusivelygames.net website. We'll take a look at the Exclusively Games Twitter. We will see some bad legal takes on that page, and then we will talk about the issues here. So, strap in. Right below me is a handy side-by-side comparison of the original logo over here and the new logo down on the right side, just the EG. Now, if you notice, there are some very similar elements to this, and that will come into play more in the trademark question. But it's actually both a copyright and trademark issue. But I just wanted you guys to see a nice side-by-side. We're going to see both of these things as we bounce around the webpage, okay? So here's the original exclusivelygames.com. This was back in, I think, May of 2020. So this isn't too long ago. And you can see we've got a lot of news articles, video game articles or whatever are here. And this is what it looks like. The things we're looking for are, trade names, trade logos, and then any art, and also overall concept. So we've got gaming features and news. We've got this Exclusively Games logo here. It's got a controller with a little quote thing, the font and the colors. Those things are going to kind of matter a little bit in the overall discussion of any real legal action. Those things are going to be scrutinized. We're not going to get into it here too much because we don't know exactly what arguments would be made, and those sorts of questions should be better saved for when actual claims are on the table. But again, high level things that you're looking for, overall concept of the site. What is it? If you don't know, Exclusively Games is supported by its audience. When you buy through the links on our site, we may earn an affiliate commission, all of that stuff. That's great. That's fine. Importantly, this is a no politics gaming news site. And that is an important part of its branding. That's the core concept of it. And we have consoles, arcade, tabletop. Yeah, so you've got some different stuff here going on. But now let's take a look at the new exclusivelygames.net, and it does look shockingly different. Now, up here, you can't see it super well, but here, you can see it there. Exclusivelygames.net has, and the EG sort of logo. Those things are going to be, again, questions when we get into trademark and copyright. Whose art is this? Is this stolen art? Is it significantly different? Is it trademark infringement? Those are going to be questions. But look at the site itself right now, and you can see that this is a very different site. This is just the forum. If you click on the homepage right here, this is the homepage at the moment. Now, on their Twitter page, they have said that they're still considering how to do the website, and the forums are up in the meanwhile. They are not super active, as you can see, but they do exist. And this concept appears to be moving, or at least it was a couple days ago, moving forward. They may have changed their minds entirely by now, and let me just say that would be the wise decision on for the people of exclusivelygames.net. The wise decision would be to reverse course, to make the website sufficiently different, even if it's a spiritual successor, but not to be using the same name, not to be using same or similar art, and to really be careful with how much of the concept you're trying to take versus how much honor you're trying to do to the community. All right, finally, we've got the Exclusively Games Twitter page, and this is one of the worst things that Exclusively Games has going for it right now is their Twitter. It's a terrible place. Exclusively Games, reborn, for gamers, by gamers. Discord is here. The exclusivelygames.net link is here. They've got some pot shots of Jeremy. These pot shots don't matter. They're pot shots and little stories about Jeremy do not matter in the scheme of copyright and trademark. This logo, this phrase right here, those are things that matter. The name Exclusively Games being the exact same as Exclusively Games, that's going to matter. And then anything where they talk about, let's see, again, these are just stories about Jeremy. That's fine. We've got, where is it? Right down here. While we decide on the website, we have launched the forums. Please join us. And then they have the story of how this came about with this series of 5 tweets. And then they said, all in all, we could have worked with Jeremy on Exclusively Games' future, but he ignored us, so we will carve our own path. 2020 is going to be good for gaming, unless you're Intel, that is. Yeah, that, again, all of this is pointing towards the idea that they are resurrecting or continuing on with an existing thing. That Exclusively Games has just removed Jeremy Hambly, or he has removed himself from the property, and that it's the same thing. That can be a branding problem when we're talking about copyright and trademark. And we'll talk about why in just a second. But I want to point out 2 bad legal takes from someone I have no idea who Tired is, Mr. Negative. He says, the best part about all this, he's screaming about suing someone who is using the name and logo of his failed website, and he never trademarked them. Here you go. You don't have to actually register a trademark to own a trademark. This is not an accurate legal take. And there's some argument that this shows that they're using the name and logo of his website, so that they are taking and using a thing that was acknowledged to belong to him, but just that he didn't register the trademark. So checkmate. That's not how this works. It's not how this works. And again, we're going to talk about it in just a minute, but I want to have all of this info on the table. Tired also says, I got curious and watched his recent video where he discusses all this and claims it doesn't matter that I didn't file for a copyright. Dude, yes, it absolutely matters. And that's partially right. I don't think it's right in the way this person means it. Let's talk about copyright, trademark, the differences, registration, all of that really quickly. Copyright is the protection of a recorded idea. That's it. That's what it is. That can be a picture. It can be a writing. It can be a song. It can be a movie. It can be anything that you can record into a tangible medium that conveys an idea, a concept, a story, anything like that. Literally any writing you've ever done is protected by copyright. You wrote a note to your friend in 3rd grade that said, hey girl, you like me, check yes, no. That's copyright protected. That it is. It's ridiculous to like consider that you would be entitled to some sort of enforcement on that or whatever, but maybe you get famous. Like, think about it this way. Maybe you did preserve that note. Someone recreates it as your note, as your thing, and then tries to sell it. That could be infringing. But really, the way copyright works is once you record something in a tangible medium, you have been given ownership of the thing at that point. You have an ownership interest in that concept, and the tangibility of it is a handy way to know that it actually exists and it was yours, and we can try and discern from the recording that it was, in fact, created on this particular date. Now, that becomes important if you're saying, I created this first or they stole it from me. You've now got a piece of evidence that the court can review, and that's why the recording kind of matters. Now, actually recording or registering a copyright with the Copyright Office is an extra step. Registering a copyright is to go to the Copyright Office and to lay claim administratively to a thing. Do you have to do this? No. Like I said, the moment you record something in a tangible medium, you have a copyright interest in it. Registering that copyright with the Copyright Office gives you a little bit more statutory protection. It gives you some presumptions about the ownership. It gives you a date, a number. It gives a supplement to your claims about what it is by saying, look, even the government recognizes this thing that I did at this time on this date. Okay, that's what the registration does. But the most important part of registration of copyright is, for the enforcement angle, is that the registration gives you access to statutory damages. Now, if you raise a copyright action against someone and say, look, this person stole my property, pirated my property, or is creating derivative works of my property, if you make that claim against them and you didn't register a copyright with the Copyright Office, you now are entitled only to compensatory damages, the actual economic loss that you suffered from their infringement, which could be basically if they got a specific economic gain. You can measure what you've lost, right? If they made $100, you presumably could have made $100, but you didn't. And they took that from you. So that's the loss. And there are other ways to prove that out, but just know that without registration, you're limited to the actual losses that you can prove. With registration, you have statutory compensation up to $150,000 per item that was stolen from you. So those statutory damages are really where things start to ramp up and where people can, be compensated. And the reason that exists, just as a brief aside, if we think about it, the reason that exists is because you create something. It has value to you, but it may not have economic market value to everybody. It may not even have economic market value to you, or you may not be interested in pursuing the economic market value of your thing. That doesn't mean that it's not valuable. So the statutory damages are recognizing the idea that what you've created has its own inherent value and you might be able to pursue something. But just because you didn't pursue monetization, or because the person who stole it from you didn't pursue monetization, doesn't mean that it's not worth something. So that's what registering the copyright really, really brings to the table. But to be clear, you do not have to have a registered copyright to have a copyright and to be able to bring a copyright action against someone. Once you've recorded the thing, you have all copyrights in it. And that includes the reproduction, the production, and the production of derivative works and the distribution of your content. You get to control that. It's yours. It's yours. Someone can't just say, well, this person's not doing it, so I'm going to do it. Nope, it's mine. And if I don't want anyone to ever see it ever, then that should be my choice as well. So that's part of the rights of ownership in anything, including copyright, is the right to exclusivity, to exclude someone from it, and the rights to alienability, to sell it off or to divest your own interests of it. That's all part of it. Copyright is best described, I guess, as a property interest in the idea that you wrote down. So there you go. So it's all of the property rights that you would normally have. The same thing as if you had a book, or well, book's not really a great idea. We'll call it a chunk of gold. Like, you own that piece of gold. You have the right to hold it. You have the right to display it. You have the right to break it down. You have the right to sell it. You have the right to hide it. All of those things are yours, and it's the same with copyright. So copyright is about a recorded idea. Trademarks are different. Trademarks are about a slogan, a logo, branding, a phrase that is important to your business. And all of these things must be used in trade or commerce. That's what it is. It is a mark of trade, trademark. Okay? So it's a mark used in trade. This is important. Is the mark used in trade? When is it used in trade? These are important things because they allow the courts to determine who has the right to use this thing in commerce. Okay? Copyright is different. It's your ownership of the idea. Trademark is your right to use this particular collection of words or this particular image or slogan or logo as part of a commercial enterprise. All right? So, do we have trademark issues in this case? Yes, of course we do. Of course we do. Exclusivelygames.com, the original website, has exclusively games, and it has a logo. It has a look to it. It's a created thing, and it's used for the purposes of the website, which is an admittedly commercial website. Now, just creating a website might not be using it in trade, but they said if you do this, we may get affiliate income. There's money going into this. It's being marketed and advertised. This thing is being used in trade. That's pretty clear. From the context of the website itself, we can determine that trade was happening. Now, like copyright, once you actually create the thing and start using it in trade, you own a common law interest in it. You don't have a statutory interest in it. You have a common law interest in it. Common law just means the law that has been developed since the time of England, and that we have adopted a common law system. So it's the law around what happens without regard to a particular law being passed. This is the law of the courts or the common people. Statutory law is are laws that are passed by a legislature. They're a statute that was passed that may give something else. So, like copyright, you have a common law mark the moment you create something and use it in trade. If it's trademarkable, and that's a different question, we'll get to it in a minute. But again, the idea of a common law mark is important because you own it once you create it and use it, so long as no one else created it and used it before you. Registering your mark is similar to copyright in that there's a record of it, it's recognized, and you can get some very important presumptions of ownership by registering your mark. And by going the further step and making your mark incontestable. Now, an incontestable mark is still contestable, but it gives you a lot of presumptions and it puts a higher burden on the other party to overcome the incontestability as well as overcoming your proof of ownership of the mark. So the registration matters, but it is not critical to the idea of whether or not you own the trademark. You own it by making it and putting it into trade. Again, very, very important. That's why I'm reiterating it over and over and over again. All right, moving through this. What is trademarkable? Trademark is a sufficiently unique slogan, logo, brand, sufficiently unique to for the purposes of identifying the trade maker, right? So we want to identify exclusively games, so we create a logo that is exclusively games and it is recognizable. Trademark infringement hinges on taking that recognizable thing and using it for your benefit rather than the owner's benefit. All right. So when exclusivelygames.net comes in and uses, if you remember, we've got these two logos right below us. They use a very similar looking logo. They talk about it being reborn. Their language around this is that they are exclusively games and Jeremy Hambley is out. All right. That's not how trademark works. I mean, when I say that, it's not working in their favor. It's actually in Jeremy Hambley's favor. So if the exclusively games logo is sufficiently unique to identify exclusively games website and therefore the Quartering's property or the entity itself, then it owns that common law mark. If they then try to take that, create a new thing, the question the courts ask is, okay, is this sufficiently close to the original? And if it is sufficiently close to the original, what is the likelihood of consumer confusion by a reasonable observer? Not someone with special knowledge, not someone who knows the backstory or the lore, but just someone comes up, they see exclusivelygames.net, they see their branding, they go, oh, this is that exclusively games website I saw one time. It's the same thing. Is that a likely outcome? And in this case, yes, it is. Well, it looks like it anyway. I guess the court would have to ultimately determine that if you really want to get down to being pedantic about it. But to me, not really knowing much of the story other than what I've read and researched for this video, it looks like they're trying to pass themselves off as the exclusively games, just with excluding the Quartering from the equation. And that looks a lot like trademark infringement if the Quartering has the trademark, which, again, I would argue, based on the information that I've seen, that he does have a common law mark in exclusively games. It has a particular look, and it looks like this new website is infringing upon that for their own benefit. And it looks like it would create a likelihood of consumer confusion. So, again, did Jeremy Hambley register copyrights? Did he register trademarks? Doesn't look like it. Does that mean he doesn't own it? No. It means that he's not entitled to the statutory protections that registration brings. Very, very big difference. He could still bring common law, trademark, and copyright claims. Now, should he do that? That's up to him. What are the questions about why he would or wouldn't? One, it's very expensive. It's very expensive to pursue these actions. You're talking tens of thousands of dollars as just an upfront. Very likely copyright actions can go, or copyright and trademark actions can get up into the six figures. You would hope they wouldn't, but they can. They're very expensive actions for both parties. You're in federal court. You're arguing over ownership. You sometimes need to bring in experts. You may need to bring in artists as experts. You have to bring in people who can talk about why this is stealing the other thing. And it's something intangible like an idea, or it's something sort of subjective like art. You have to convince a judge that this is or isn't the same as the prior thing. These things get expensive. So that's one reason you might not want to do it. Reasons you might want to do it are One, damages awards, right? Like if you think you can recover money sufficient to outweigh the cost of suit, then that could be valuable for you. If you are sufficiently wealthy to eat the cost of the suit and you get some other intangible benefit from it, you're protecting your brand, you're protecting your own reputation. Those sorts of things can actually be a valid and desirable outcome for someone, even if the money isn't. The likelihood of this being a high damages case is pretty low because there isn't registration. So Mr. Hambly would have to determine whether or not he wants to eat the cost on the of the lawsuit for the other purposes, such as reputation, such as brand protection. If he plans to revive exclusively games sometime in the future, he definitely wants to pursue some sort of defense of his brand. He wants to do that for the purposes of the trademark. And that's something that we should finally talk about, and that is abandonment. And this will probably be one of the arguments that exclusivelygames.net would raise in any sort of hypothetical. Abandonment of copyright is not a thing. Basically not a thing. It's theoretically possible to abandon a copyright, but generally speaking, you own the idea until you decide not to own it. You need to alienate that's alienability, right? You need to alienate yourself from the property. You need to divest your interest of it. And typically that comes with assigning that interest to someone else explicitly. Again, it's theoretically possible, but largely we're not recognizing abandonment of copyright. Trademark abandonment is very, very different. Once you stop using a name in commerce and stop defending it, there's a clock running on when the trademark is abandoned. It's not automatic. It's not, there's not a set necessary formula. There are some guidelines out there, but the longer you go without using something in commerce and without defending it, the longer that that trademark begins to look abandoned, right? It's the difference between if you leave a wallet on a table, you may intend to come back to it, or you may not. We don't really know. If you leave a wallet on a table for 2 days, I mean, maybe you got really drunk or something. You leave a wallet on a table for 2 weeks, you may not be coming back, right? Like these are the ideas behind abandonment are at some point we say, okay, this person isn't coming back. But truly abandonment rests in the intentions of the users. But there has to be a cutoff point. So Jeremy Hambly has to protect his trademark if he wants to protect it from abandonment. And that would be, again, a valid reason to bring suit. So let's recap really quickly, because there's a lot going on here. I know there's a lot of info. If Jeremy wants to keep this property, should he bring some sort of legal action? That's up to him. Right? That's up to him. There are different legal actions. You know, you could do DMCA takedowns. You could do official copyright claims in court. You could send threatening letters. You could send enforcement letters on the trademark. You can do all sorts of things to assert your ownership and document that very well. Should you ever need to go to court on it, those are things that you'll have to do. Or you could just straight go to court on both of these issues. He could do that. The risk, of course, is that the other people may not have any money to take, or that the damages may not be really that big. Now, even if you have $1 of damages, you are technically legally entitled to enforce your right to that dollar of damages. So I want to dispel that notion really quick. Just because damages may be low does not mean they're invalid and does not mean you can't bring suit. Okay? You are entitled to enforce even down to novel or de minimis sorts of damages. You're entitled to that recognition. In some cases, you're entitled to just the mere declaratory relief from the court that you own this and the other person doesn't, and they need to stop. Also, injunctive relief. They need to stop using your particular thing. Okay? You can decide whether or not that is worth it to you. So, can Jeremy bring suit on these things? Yes. Should he? Up to him. Will he win? Who knows? Who knows? There are competent arguments you can make on both sides, but I think the needle does tip in favor of Jeremy on this one. He owns the original content outside of some proof that he doesn't own it or that he gave it away. It's his. Taking it just because you think he's not going to use it in the way that you want doesn't mean that he doesn't get to have it. So that's a really important aspect of this. The needle, in my opinion, so far, based on what I've seen, tips in favor of Jeremy. And if he chooses to enforce his rights, it could be very, very ugly for the exclusivelygames.net crew. He has said that he has all of this archived. He said that he knows all the names. Lots of internet puffery going back and forth, and that's fine. When it ultimately comes down to it, if he has the receipts that he owns the stuff, and they don't have receipts that it's been given to them, they're in a lot of trouble. And the interesting thing about all of these threats and the online bombastic nature of everything is they could change course right now and probably head off all of this. So they should probably consult an IP attorney and figure out what's going on. Jeremy has made a public statement that he is considering legal action, that he sent this stuff to his attorney. It would be wise for them to get some sort of consultation going with someone and figure out what their options are at this point. So I hope you guys found this informative. If you did, please like, share, subscribe, all of that stuff. I know this is a long video, but there's a lot of meat to this topic, and I wanted to cover as much as possible and to also cover the existing bad legal takes that people are making on this. Again, I hope you liked it. Hope you had a good day. Peace. Peace.